following program is classified G. It's suitable for all ages.
Tonight, we discuss the provisions for fundamental rights in the Sri Lankan Constitution. The public discussion forum has often been met with the court procedures that follow FR petitions, especially during times of a new amendment to the Constitution. The importance of these hearings are outlined by the impact it makes on legal decisions for years to come, as it deals with the most basic rights of citizens in Sri Lanka. But what are the nuances of these procedures, and how can we better understand it? Is there a requirement to reform the approach to these inalienable rights of Sri Lankan citizens? Welcome to Law, Land and Liberty, where we are keeping with the promise of bringing in a contemporary legal motion and bringing it down for our viewers. Today is a very important topic, I would say, something that is fundamental to all of our existence, and that is where the name derives itself, the fundamental rights. We're going to talk a bit about the petitions, we're going to talk a bit about how fundamental rights are protected within our Constitution, and for that we have none other than an expert within this field, a person who has been within the reformation process of this field as well for quite some time, President's Counsel Manohara Silva. Thank you so much, sir, for joining us today. As we usually take this program forward, we give you a breakdown of what we are going to say so that the viewers can really follow the entire discussion. Firstly, we are going to talk a bit about the types of fundamental rights identified in Sri Lankan law. Then a bit about the principle of locus standi, which is going to talk a bit more about the court process and the time durations and all the technicalities that are involved there. Thirdly, a bit about the compensation and the court action process that comes into play when we are talking about fundamental rights. And finally, about the reformation process.
Hi, my name is Malki. I'm currently working as a billing analyst. My question is regarding the fundamental rights in Sri Lanka. What are the key fundamental rights identified within the Sri Lankan Constitution?
Thank you once again for joining us. We'll dive right into the discussion. As you were saying, it's quite important, something that has been contemporary and something that you have been engaged with for quite some time. The most basic law, but yet somehow becomes the most complex at certain points as well. How do you approach the topic? Now, for the first segment, what I want to ask you was, people are a bit unclear about what their fundamental rights would be, as in where the boundaries would be drawn. Everything would convert into a fundamental right at the same point, like they wouldn't be too clear about what the rights are enshrined within the Constitution. So I give it to you, sir, to approach the topic. How do you understand the concept of fundamental rights here?
Yes, fundamental rights chapter was introduced for the first time in 1972. When we first got Sri Lanka became a republic. In the first Republican Constitution, they included a Bill of Fundamental Rights. Then in 1978, also we incorporated a Bill of Fundamental Rights. If we just run through some of those rights, Article 10 to Article 14A, there are 6 articles in which identifies the respective fundamental rights that the people are entitled to. The first one is in Article 10, every person is entitled to freedom of thought, conscience and religion. Then Article 11 deals with that no person shall be subject to torture, cruel, inhuman or degrading treatment. Article 12 is that all persons are equal before the law, and are enshrined to equal protection of the law. Article 13 is that no person should be arrested or detained except according to the procedure established by law. Then we come to Article 14. There are sub-articles which I have only broadly defined those. Article 14, there is something special in Article 14 because Article 14 is limited to citizens, right, whereas freedom of thought, conscience, torture, all that is, all persons are entitled.
Right.
Now, under Article 14, freedom of speech, freedom of peaceful assembly, freedom of association, freedom to join a trade union, then freedom to promote one's religion and culture, then freedom to practice one's profession, and so on. So those are the basic rights. Under the 19th Amendment, a new fundamental right was introduced, that is the right to access information. Now this is some important right where you can apply for information which is withheld by a state institution.
Right.
So those are basically the fundamental rights that is incorporated in the Constitution.
So now Article 14 has been something that has been contentious. One would say there's a lot of clarity that was required there. So we'll spend some time on it. But before we get there, I think if we can clarify the causes of action now. People hear the term fundamental rights petition was filed in Supreme Court. This is what happened. But if I'm not mistaken, I wanted to take this up in our second segment also about there are certain provisions to file if it's a private action. It will be under district court. So can you clarify that dichotomy first, because we are not too clear about it.
Yes, fundamental rights actions, if the fundamental rights are violated by administrative and executive action, then you can invoke the Supreme Court.
Right.
Now that's the difference between the 1972 Bill of Fundamental Rights and 1978. In 1972 we had the Bill of Fundamental Rights, but there was no specific provision in the Constitution for any person to go to court and get it enforced. So the bill was, the rights were there, but was not enforceable in that sense. So in 1978, for the first time, the specific provision were incorporated in the Constitution, so that if there is any violation of a fundamental right, you can petition the Supreme Court.
Right.
And the Supreme Court can give you relief. Of course, you have to do that within 1 month of the violation.
Right.
Another important aspect is that only the person whose rights were violated could go.
Okay.
Unless, of course, in a special case where somebody is tortured and killed in a police station, then in those circumstances
The relatives,
relatives can
Right.
file. Otherwise, you have to file. The other exception to that rule, which has developed through decisions of court, is that in public interest litigation, in the interest of public,
Right.
for any person could invoke the jurisdiction, even if it doesn't particularly refer to your own right, but because you as a community, you're also part of the community, you could invoke in the interest of the public.
Right. So before we get into details there, because I want to get a elaboration on the technicalities. The PTA, something that has been in contention for quite some time. How does, now when we talk about fundamental rights, we also have to talk about the exceptions that come with it. Does the PTA follow a similar trajectory, as in we see this in the public forum for quite some time, people have divided views on the implementation of it. Are there, I think there are exceptions, but to which extent can those exceptions go? And I think the procedure to implement those kind of laws are quite stringent, but what are the exceptions that are there?
No, there is a misconception that fundamental rights, that you need to realize that whether it is the PTA or any other law, fundamental rights are not unrestricted.
Right.
There are only two categories of fundamental rights given in Article 10 and 11.
Right.
That is freedom of thought, conscience and religion is called an absolute right because it cannot be restricted.
Right.
You can decide whether to be a Christian or a Buddhist or a Muslim, but you cannot restrict it. The government can't say you can only follow Buddhism or you can only follow Christianity.
Yeah.
So in that sense, it's an absolute right. Freedom of torture for no reason, whether you are a criminal or whether you have done the worst crime, no torture is possible. Other than those two exceptions, any fundamental right can be curtailed.
Okay.
It has to be, because anywhere in the world that is so. If I give you an example, suppose in a particular, even with regard to religion, although the right to adopt a religion is unrestricted, the manifestation of a religion is subject to restrictions.
Okay.
Say for instance, if there is a particular religion, I'm just giving a hypothetical example, if supposing a particular person believes and his religion is to kill other people whom he dislikes, now that is not something that, although it may be a right from the perspective of your religion, the state can intervene and say no, you cannot, or supposing even with regard to animal rights, supposing there is a particular ritual which permits somebody to kill certain type of animal, the law can, the state can intervene and say no, you can't kill animals, although it may be part of your religion. So likewise, manifestation of religion, or even with regard to building of churches and temples, the state can intervene and say no, you can't build temples and churches wherever you want. Okay. You have to follow certain procedure, or you have to get permission from the state. So anywhere in the world it's like that. So with regard to other rights other than torture and freedom of thought, conscience and religion per se, in the sense of the right to adopt a particular religion, other than that, manifestation of religion, the right to join a trade union, or to express views. Now you may have the right to express views incorporated in the constitution, but those are subject to restrictions. That is, I can't, for instance, merely because I have the right to express views, I cannot make use of that right to defame you. So always a right can be restricted. Now the PTA also is like that. PTA also, there are certain limitations. In the interest of national security, in the interest of public security, you can't allow people to kind of say, for instance, you may have a right to have some kind of a weapon, but the law will intervene and say, no, you cannot possess weapons, or you cannot use a weapon. So like that, you can have restrictions, which is the case anywhere in the world.
Right. So I wanted to ask you a bit about the respondents aspect of this also, but I believe that will lead us to the talk of how to structure a petition. Before we go there, we'll take a very short break. You are watching Law, Land and Liberty. Stay with us.
My name is Ruben. I work at Eon Next as an energy specialist. My question to you today is on the court processes in place for fundamental right petitions in Sri Lanka. What is meant by the principle of Locus standi, and what are the key aspects one should know when filing a fundamental rights petition in Sri Lanka?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Manohara de Silva. So within our first segment, I think you gave a very comprehensive breakdown of what the fundamental rights are that are enshrined within the Constitution. My next question is going to be leading towards the petition aspect, which is something that you'll be engaged in doing. It is said, as in when we follow, as law students, when we follow it, the respondents should be identified clearly, and if you can't, you have to mention that within these petitions. Just explain to us if because one would say that they wouldn't be too clear about who the respondents would be in a certain case. In those instances, how does the
the first principle is, if you are making any allegation that any particular person has violated your rights, then you have to make that person a party, because for the court to give a decision, you have to hear both sides. It's only after hearing both sides that you can give a decision. So you have to make the person whom you say violated your rights must be named as a respondent. Then also, if from the relief that you are getting, if somebody else's rights are affected, then such a person also should be made a party. I'll give, if I take a small example, supposing you are saying that you were denied a particular promotion in the public service. So, and who did that? Maybe the head of department selected the wrong person, and you want to go to court. So you have to make the head of department a party, or if the appointing authority is the Public Service Commission, you make the members of the Public Service Commission parties. But at the same time, it is also important, if you ask in the court to nullify the appointments and give it to you, because you are saying that somebody else was wrongly appointed and you want it nullified, then it is nothing but correct to listen to the person who has got the appointment. So if there is anybody who will get affected by the decision that you are seeking from court, then such a person also should be made a respondent. Then also there can be situations where somebody who influenced or helped the public authority in violating your rights. Now, for instance, supposing you are taken at the police station, a police constable assaults you. So who violated the right? The constable violated the right. But the OIC was watching you. Probably he was in his office in a glass cage, and he didn't do anything. He didn't encourage him, but he just kept quiet. But he can very well see that you are being tortured. Now the fact that he did not intervene, although he had all the opportunity of doing so, and being the head of the station, he can be made a party because he assisted in committing that crime.
Through omission.
Through omission. So you can file a fundamental rights not only because somebody did some act in violation of your rights, you can also file a case where through inaction, if your rights are violated. So those are the people generally, and also of course the Attorney General must be made a party. Now this is very important because sometimes even in the department, often people tend to believe that the Attorney General is there to safeguard the rights of the state, or the violator. If you were assaulted by the police constable, probably the Attorney General will appear for him. But the duty of the Attorney General is not only to see the interests of the state, but also to see the interests of the people, the petitioner who complains, because he is an office of the state who has to ensure the protection of fundamental rights by all organs of government and those responsible in engaging in government activity. So actually the Attorney General has a dual role. On the one hand, he has to protect the rights of the state as well as ensure the rights of citizens. So he has a very big role in a fundamental rights application. So it is imperative that although he may not have done anything, you have to make the Attorney General a party.
So just to, I think we're deviating from the topic a little bit, but I wanted to clarify, are there instances where you see the Attorney General now, if the Attorney General is to do a bit of a role like the judge and to really understand with what happened to both either the petitioner and the respondent, does the Attorney General have the capacity to step down from representing a certain client, or will that be a requirement?
That often happens because sometimes when if the Attorney General, after examining the brief, comes to the if it is in his view that the person has in fact tortured, then and also eventually the Attorney General will have to prosecute him in the High Court. So he can't be defending him in the Supreme Court and prosecuting him in the High Court. Now in a situation like that, he'll he'll ask him to retain private counsel, and the Attorney General will refuse to appear for him.
That makes sense. Sir, another thing, since we came to the subject of a petition, and this is one of the most important documents when it comes to fundamental rights, we have heard that an individual could submit a letter to the Supreme Court. If it's not through an official petition, I'm also not too clear of the process. How can you submit a petition and make how can we submit a letter to the Supreme Court, and then if there is a case, a prima facie case there, how does that convert into petitions?
Yes, and actually this happened in America, right, when a prisoner sent a postcard, right, saying that I think my rights are violated, please look into it. Yeah. And the Supreme Court took it up. Okay. So after that particular incident, many countries adopted that principle, and even our Supreme Court, when they were framing their Supreme Court rules, put a specific provision where you can, by a normal letter or even a postcard, you can complain to the Supreme Court, and the Chief Justice will get one of his judges to inquire into it, and then call upon either refer that person to the Legal Aid Commission for assistance, right, or get any other law, request attorney to appear for him, and that attorney can draft a formal petition, right, on behalf of. But the initial application was made by a normal letter. That is possible under the rules of the Supreme Court, even in Sri Lanka.
Even in Sri Lanka. So just moving forward from that point onwards, I believe, if I'm mistaken, just please correct me, Article 126 is what elaborates the time period. Now, this segment we wanted to dedicate to the locus standi principle, as in whether you have the right in terms of filing that specific, or to identify that specific fundamental right, whether it has been violated or not. What are the elements within the principle of locus standi, and if we can then move on to whether the time period, the time constraint also applies to locus standi?
Yeah, generally, in a normal public law litigation, you must have some kind of an interest. You can't be just a busybody. But fundamental rights, in our fundamental rights section, Article 126, which you mentioned, specifically says that the person whose fundamental rights were violated must invoke the jurisdiction. Okay. So it is limited to the person whose rights were violated. Okay. But there are only two basic exceptions which is recognized not in the Constitution itself, but through judicial decisions. Common law. As I mentioned to you earlier, if somebody is killed in the process while in police custody or something like that, the heirs can file action, or in the public interest,
they can bring up a case.
Yes.
If we can go into a bit more detail about this issue of public interest and the dichotomy that exists between personal grievance. Now, public interest could mean a lot of things, and people would take it in a lot of ways, and we have seen this happen sometimes to the extent that the court has to spend a lot of time and energy on entertaining certain issues that may not even turn out to be a fundamental rights issue. What construes public interest or public grievance in that scenario? Is there common law that really supports that? What are your experiences with it?
Well, often you find abuse of this freedom also. Yeah. But of course it's a good feature, because after all, when a fundamental rights case is filed, before the case is taken up, there is a hearing, where we call the stage of granting leave to proceed. Right. So your petition is first heard by 3 judges, and they will decide whether permission should be granted to proceed with it. Right. So if you file a frivolous application which has no public interest element in it, then it will be thrown out and probably subject to even costs, right, to be paid to court. Right. So there are safeguards, okay, but I think that right to invoke a public interest action is an important element, although it is sometimes abused. I won't say often, but sometimes abused. Still, I think that's a very important right.
Right. I want to talk a bit about the court action, things like the writ and the compensation aspect of fundamental rights, but we'll take a very short break. You're watching Law, Land and Liberty. Stay with us.
Hi, my name is Ravindu and I am a biological sciences major, and my question is on relief provided by courts. What are the key relief measures that court allows in cases related to fundamental rights?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Manohara de Silva. So this segment we wanted to separate a bit to what kind of actions the court can take. Now, just to prompt that scenario within a petition, I leave you to it to explain, sir, about the prayer and what we can give as the expectation from the courts. I think that's required in this scenario.
Yes. Now, generally, you can ask the court, and in every case, you ask the court to declare that your fundamental rights are violated.
Right.
Now, a mere declaration won't help you.
Yeah.
For instance, if you are tortured by the police, or you are injured and you had to spend for your medical expenses, the court can direct compensation to be paid by the perpetrator of the crime.
Right.
Now, if you take another example, like where your promotion is denied or your appointment is denied, then the court can direct to give that appointment. Apart from the declaration that your fundamental rights are violated, the court can say, cancel the appointment given to X, and you have to give the appointment to the petitioner.
Yeah.
Or the court could say, cancel all appointments and have a fresh interview.
Right.
And do it according to law.
Okay.
So like that, it's not the mere declaration of a right, but the substantive relief that you want to, the tangible relief that you want to get,
yeah,
you can ask from court. So you ask for a declaration in the first instance,
yeah,
then you ask for that specific relief which you require, and maybe on occasions where compensation is possible, you can ask for compensation and costs of litigation also.
Right. If we can go a bit more, now all of this should be identified within the prayer section of a petition, is it? Is that how it's going to work? So the next question I would have is, like in the case of respondents, where you have to name and you have to be careful about who you name as respondents. Within the prayer, should we be specific, or does the court take it upon themselves to award the required?
No, it is very important that's why you need proper legal guidance, yeah, to file a fundamental rights application. And I think the public should know that we have a very active legal aid commission,
right,
which has about 80 branches throughout the country.
Okay.
So if you are a person who is unable to retain the services of a lawyer, yeah, who practices in the Supreme Court, you can always, and if you do not have the finances, not everybody, but if your income is if you are a low income earner, you can approach one of those centers,
right,
of the Legal Aid Commission and seek.
Okay.
Because it is important that this, to answer your question, must be legally done. If you don't ask in the prayer, you won't get it.
Okay.
The court can grant you relief what you ask.
Yeah.
So sometimes if you are not a trained lawyer, you may not properly draft your prayer and ask the correct relief that you really need.
Right.
Now, for instance, if you just ask for a declaration and does not ask for your job, please appoint me to the post of such and such,
yeah,
then the court might give that declaration and not that relief. Of course, I must say that there is nothing to prevent the court from giving it to you.
Okay. Okay.
The court has the power to do it.
Right.
But it is always better for you to ask those reliefs,
Right.
because you are required to ask what you seek from court. But of course, the court itself can, if the court thinks that there is some injustice that has happened, even if you have not prayed for, nothing prevents the court from giving it. But the law requires you to pray, so it is safer, and always the proper way of doing it is to make that application.
Right. So I want to ask a bit about challenging private acts, but before that, if I could make this clarification. The Court of First Instance for Fundamental Rights more often than not is the Supreme Court, and what we know is there is no appellate procedure for that. Is that the same in this? Will that rule still apply if we have a technical issue, maybe a prayer hasn't been worded properly, maybe the respondents have been identified properly? There is no appellate procedure after that. Is that the case? Yes,
Supreme Court is the apex court of the country, so there is no appeal beyond that.
Yeah.
So you have to. That is why it is very important that when you file cases in the Supreme Court, it must be perfect.
Yeah.
Otherwise, you run the risk of it being dismissed.
And you can't file it again.
Yeah. So that's why it is important. Either if you can't do it, you don't have the resources. That's why I specifically mentioned that you can always seek the assistance of the Legal Aid Commission to do it.
So the next question is going to be on challenging private acts. Now we spoke, I think you were very specific when you said it, and I wanted to interrupt you there, but if you can get the clarification now, it won't always be public officials, public entities that the issue of fundamental rights will be raised. There's a clear dichotomy for criminal issues where you say, okay, the state is the one suing the individual who is suspected of conducting a certain criminal activity. But when it comes to private acts, maybe in a private company, maybe a private school and the admissions process there, how does it work? And can it be brought up to the Supreme Court, or is it a separate court?
That's a very important question, because actually this is something that lacks in our system, which when we were drafting the new constitution during the previous president's tenure, this is what we have drafted, and we have given it to him, but unfortunately he's no more
there.
holding office. What we'll
go into details.
Yeah, we suggested that even with regard to violations by private individuals.
Right.
Now, for fundamental rights chapter deals with only violations of the executive branch of the government. So if it is a executive or administrative act, you can go to the Supreme Court.
Okay.
Even presently, if a private person feels that your fundamental rights have been infringed, there is nothing prevents you from invoking going to the district court and ask for a declaration, because under the Civil Procedure Code, you can ask the district court to declare a right or status. So in that sense, you can file a normal action, a declaratory action, and ask for relief. But as you know, the district court process is very time consuming, and it has other legal issues involved. So what we suggested also in drafting the new constitution, that if there is a violation by a private company or even an individual, say for instance, if you are supposing a hotel says this hotel is open only for foreigners, or say a particular community is deprived, then you cannot file a fundamental rights here in the Supreme Court.
It has to be in district courts.
It has to be probably in the district court, and to get relief in that process is difficult.
Right.
So it is important that we enlarge the jurisdiction of the Supreme Court. So what we did was, with regard to those rights, we suggested that the Court of Appeal exercise those rights in situations where the violator is not administrative or executive, but by any other person.
Right. Before we go into the reformation aspect, if we can, as a final question for this very segment, what would you say would be the time period or the time frames when it comes to compensation or court action when it comes to fundamental rights petition cases done in the Supreme Court? Are we in that? Are we competitive in terms of efficiency there, or what would your comments be on that?
Yes, of course, there is a big complaint that the time that it is taken in the Supreme Court, that is because there are so much of fundamental rights cases filed, and Sri Lanka, not because actually they are very conscious of their rights, I must say. With all our, even in comparison to sometimes other countries, Sri Lankans have been quite conscious of their rights, and you find a whole heap of fundamental rights being filed, and there are about only 17 judges in the Supreme Court, and for each session you need at least 3 judges, so not more than 3, maximum 4 courts can sit on a given date. So each case might take several hours. When they have to hear both sides, the Attorney General and the respective parties. So only few cases can be heard every day. So because of that, there is a delay. In terms of efficiency, I think we need to revisit and see how we could improve that by
there's a legitimate practical problem there. So I want to go into details about the reformation process. You have done a lot of work in that instance, and we can go into details on that. We'll take a very short break. You're watching Law, Land and Liberty. Stay with us.
And I'm an economics graduate. My question is on legal reform. What are the most important reforms required in refining fundamental rights in Sri Lanka?
Welcome back to Law, Land and Liberty. We are in our last segment and we are in conversation with President's Counsel Manohara Silva. So very fruitful portions that we have been passing so far, and a lot of work that you have been part of over quite some time. Firstly, in terms of contributing to the common law by bringing in a lot of important cases, and now directly involving yourself in the reformation aspect. Questions have been asked, and I believe we had a lot of lawyers sitting there and who have really tried to push this reformation process within the past few years. Where does that lie in relevance to fundamental rights? What were the propositions that you all made, and where should we be going?
Yes, we looked at it, the fundamental rights chapter, actually from our perspective, looking at our cultural and Sri Lankan setup. We thought that fundamental rights must always be coupled with fundamental duties.
Right.
So as at now, we only have a Bill of Fundamental Rights. We don't have a chapter where fundamental duties of the state can be enforced. So the chapter that we have, the committee consists...
Sorry to interrupt you, I think it's a very important point you're making, but if you can, I would understand what you mean by duty and right, but how can you make that differentiation to the people that are viewing? What's a duty in this scenario?
Yes, now a duty is the something that you are supposed to do for the
state.
Yeah, for the state or maybe an individual. Now I'll give you an example. Maybe there are duties. Now we know what duties are. We have duties towards our parents. We have duties towards our siblings. Now we have identified duties of the citizen as well as duties of the state. So it is important that apart from the rights of citizens or rights of persons, to identify a whole list of duties of the state. And I think it is something that if I just have few minutes to refer to some of those duties that we have mentioned, where a person can invoke the jurisdiction of the Supreme Court and ask the court to ensure that those duties are performed. Not because your right has been violated, but
This is a duty.
if the state has a duty. Now, for instance, we have now I'll just give one or two examples. To ensure that food cultivated, manufactured, imported, exported, offered for sale is fit for human consumption.
Quality control. Yes.
Quality control. Because otherwise, now that's a duty that the state has to perform. Then to regulate the use of agrochemicals and other chemicals harmful to health. Then to ensure the maintenance of essential supplies and services. Now we were facing these issues of gas. When we drafted this, there was no default of supplies.
Right. But you saw that coming.
Yes. Things like that, to ensure that subject to the provisions of the Constitution or any law, all at any public office are based strictly on appointments to any public office is based on strictly on merit. Right. That you can't get a letter from a politician and get a job. It's meritocracy must be recognized and enshrined in the Constitution.
In any stage of that.
Yes. Then that the citizens have access to safe and nutritious food and water. Then to provide adequate social security to senior citizens. Then also to provide access to hospitalization, basic healthcare services. True enough, we now get it, but the way things are going, we can find a situation where those services are not properly given.
So I would just to, sorry if I'm interrupting, but if you could also tell us some of the duties, because I'm more interested in hearing some of the duties that the people have, because that is something that people try to always negate, put the burden on the state always.
Yes. Now, out of those, the citizens to uphold and defend the Constitution and refrain from violating the Constitution. So not only the state should protect the Constitution, I think citizens. The people also should. Now we heard sometimes people saying, no, we must throw the Constitution, now we must burn the Constitution. Now that is not something that a citizen ought to do. Then to honor the national anthem, national emblem and national flag. To preserve and protect public property. To respect the rights and freedom of others. To work conscientiously in his chosen occupation. To render national services when called upon to do so. A citizen who is a parent or guardian to provide opportunities for education to their children. Now in that regard, we have also, there is a corresponding duty on the state to provide the primary and secondary education.
Universal.
Yes, to all children.
Yeah. I think it's great that you showed this and introduced this to the public. If you please go into details if there are other suggestions that you want to.
Yes, now those are the duties. Very briefly, I mentioned. Then we have introduced new rights. Now I mentioned the rights that exist now. Now we have also introduced a new right called right to life. Then also the right with regard to rights relating to environment, that the state has to protect the environment. Now we find sometimes on the guise of development, environment is totally forgotten about. So that's a right that you can get the Supreme Court to enforce. Then the right to just administrative action. If any public officer is taking any administrative action, he must ensure that the proper just procedure is followed. Then also equality and fair treatment in employment. Just to give few, the right to primary and secondary education. Then right to peaceful enjoyment of property. The right to privacy, family life, and protection of personal data. Right to medical care. rights of senior citizens, rights of persons with disabilities. I'm not elaborating because there is hardly any time. Then right to free and fair elections. So those are some of the rights which are not incorporated in the present constitution. That was
going to be my question, because people would hear this and wonder and think that they expected these to be enshrined within the constitution, but it is.
Yes, of course we must realize that 1978 constitution was drafted 40 years ago, and actually it is more or less a copy of the 1972 constitution. So it is almost 50 years ago that these, and now with the society has kind of evolved to a very great extent. So 50 years later we can't have the same set of rights.
True.
So that is why it is important that we, without bringing amendments to the constitution as we see 22nd, 21st, and it is important that we draft a constitution with all these rights ensured, and more than those rights, to ensure that the duties of the state are enforceable, so that the people's rights and duties are secure.
Right. I have so many other questions to ask, sir, but I want to ask one final question before we end the program. I know there are a lot of young lawyers, the people that are studying law, and the laymen that watch this program who would want to know, given that you have been, you're a very experienced person within this field, what sort of advice do you bestow on people? Because I see that you're putting a lot of work in trying to create a better, more forward-looking constitution and more forward-looking legal system. What is the sort of advice you give to the young lawmakers, or even the legal officers, the young law students, to engage in, or to be more present in, or to understand better before they make rash decisions? We have seen, let's not name any, but before they make any rash decisions, what form of advice do you give to them?
Well,
in relation to fundamental rights also.
No, yes. Now I think it is important that people identify social issues. Say for instance, now the talked about topic today is corruption. Everybody says there is corruption, and everybody talk of various 21st Amendment, 22nd Amendment, 19th Amendment, 18th Amendment. Now, have we addressed the issues of corruption? So the message that I want to give, not only law students and young lawyers, as you said, but even the general public, is we must ask this question: all these laws that the government and various organizations propose, do they meet the demand of eradicating corruption in this country? Now, if the answer is yes, that's fine. But unfortunately, if you read the recent amendments that were gazetted, there's hardly anything that you find to eradicate issues on corruption, issues to see for the country to progress. Right. Now, those are issues that the youth, the young lawyers, and the general public must focus on.
Right. A very good note to end our discussion. President's Counsel Manohara de Silva, thank you so much, sir, for joining us on this day. I hope you join us again for another program, because there's a lot more for us to talk about.
Of course. Thank you so much for the invitation.
All right. Fundamental rights, its identification and protection, is the keystone for the rest of the legal framework to function. This is most clearly witnessed by the Supreme Court taking precedence in dealing with FR-related cases. B.R. Ambedkar, the former Minister of Law and Justice in India, once shared these thoughts pertaining to fundamental rights. What are we having this liberty for? We are having this liberty in order to reform our social system, which is full of inequality, discrimination, and other things, which conflict with our fundamental rights. That is all from us here at Law, Land and Liberty. If you had missed today's program, you can rewatch our entire episode on our YouTube channel, youtube.com/Ada English. Join us again next week as we break down a contemporary legal topic. I'm Dandy Tanmasa. Have a great night.